bring in Sushil Pandit, who actually filed this case in the first place. Sushil Pandit, there are many who are questioning why has it taken 14 years for this case to be finally, receive prosecution sanction? Is the timing political? Is a question that is being made.
Madhav, I can't speculate on this issue. The question should be answered by those who sat on these files and decided to pull them out now for action. In fact, there should be an inquiry on this also, and heads should roll as to why this was held back for so long. They should also face consequences for impeding the, as they say, the course of the law that it should have taken in the last 14 years. Now, be that as it may, 14 years ago, when this travesty took place, when openly in the heart of our capital, a call for destruction of Indian Union as a colonial state, as an occupying state, as a state that had subjugated people in Tamil Nadu, in Punjab, in Northeast, in Kashmir, had no business to survive. When such statements were made, when call to arms rang out from the podium, repeatedly by Syed Ali Shah Gilani, by Varavara Rao, by Arundhati Roy, when these things happened, the then Home Minister was trailed by the reporters, the journalists, as to what action he proposed to take. After 1 week of dodging them and ducking, he finally said, taking no action is also an action. It is then that I thought, as a private citizen, I should move the court, I should move the police and seek some action against this. Now, if from the very top you have this mindset, none other than Chidambaram, the Home Minister, says so publicly, pompously, then there is something absolutely rotten in the state of Denmark.
Right. Mr. Pandit, I must also ask you.
Because when the government changed, for 10 years we had a different government, a different prime minister, a different home minister, a different party altogether. A party of muscular patriotism. What did they do on this case? Except sitting on it and not doing anything. I had given up all hope. I hope now the path of law will not be impeded and it will be allowed to take its course, as they generally are fond of saying. Yes, you were asking something, Madhav.
Yes. There are several questions that arise from this. Of course, even freedom of speech has its own reasonable restrictions that we were discussing. But there are those who are questioning whether this is a reaction to what the Supreme Court has said vis-a-vis sedition and, the restrictions as far as sedition case that have come in from the Supreme Court. Is this an alternative legal path to go ahead and prosecute Arundhati Roy that is being looked at? Is a question that some of our legal panelists have observed. How would you respond to this?
See, though it is the insistence of a lot of people that sedition as a law is outdated and colonial, none other than Supreme Court itself had defined the basis on which sedition could be invoked. And it was Supreme Court in independent India. And this case meets all those conditions because call to violence was unambiguously made. And dismemberment of the country was called for. Also, it led to breach of peace. Police had to take up protesters, detain them in the police station in order to avoid breach of peace. So every condition that is prerequisite for invoking the law of sedition existed. Now, if Supreme Court decides to amend its own view few years later, it is their prerogative. But laws are something that our parliament makes, our elected representatives make, and Supreme Court is only there to interpret them, not to make their own laws. I think it is the duty of elected representatives to uphold the integrity of the country, no matter who violates it. No matter who violates, it is equal for everyone. And therefore, they must face the consequences of their action, even if 14 years later.
Absolutely. And one of our panelists, Mr. Pandit, I believe we have Karuna Nandi with us. She wants to pose a question to you. With your permission, I'm going to allow her to ask you a question. Karuna Nandi.
Thank you. I'd like to say something very briefly on what the law is. Now, regardless of what the law used to be, today the law on sedition has been stayed, pursuant to a constitutional challenge to the entire law. So your impression, sir, on what the law is what the law was. right? Because prosecutions have been stayed. Now, with regard to your other sections, and perhaps your lawyers have not informed you of this, with regard to the other sections, Section 468 of the CRPC provides some limitation because those are all provisions that of prosecutions under 3 years. So one appreciates the fact that yours is not a currying favor, politically motivated prosecution. But the thing to understand is that under the law, your entire prosecution and all those provisions would either have been stayed or would have lapsed.
Okay.
But for this UAPA.
Okay.
You must ask yourself that tomorrow if somebody says something about, say, for example, there was a panelist here who was saying that so-and-so should have died in prison, right? Do you want a society where there is discussion, where even under the Supreme Court judgments of Shreya Singhal, etc., that there is even advocacy?
Okay. I'm just going to come in now, Karunanidhi, because we have very limited time. I'm going to allow Sushil Pandit to quickly respond to you and the concerns that you have raised. Sushil Pandit, your response to Karunanidhi.
Yes. I think a lot has been allowed to pass under freedom of expression. Even Supreme Court says that this fundamental right is not an absolute right and it is subject to certain restrictions. In your point of view, calling for dismemberment of the country, calling for violence to achieve this objective is within the ambit of freedom of expression and should not be restricted to reasonable restrictions. Then I'm afraid.
I hear you, Mr. Modi. I hear you, Mr. Modi. But if you look at the video clip that was played, she did not call for violence, right? She used the term azadi. Now, if we look at what the Supreme Court has said precisely, and I have that judgment in front of me, it says that...
you don't please talk about one clip. I sat there and I heard her for 45 minutes.
But
please
Mr.
listen
Modi,
to the entire speech.
Mr. Modi, what she's being prosecuted for today is using that word azadi. And let's look at this. That advocacy is different and incitement is different. Incitement to violence is different. Mere discussion or even advocacy of a particular cause is at the heart of Article 1918. What I'm saying to you today, right, is that if people asked for, said something, if a Kashmiri Pandit, for example, said something against another community, said something like X should go to Pakistan. Now, this is horrible. And this is something that is not acceptable, according to me, according to the values of our society.
Wrong analogies.
One by one. Karna, you made a point. Let Mr. Pandit, Sushil Pandit is his name, by the way. Let Mr. Pandit respond. Yeah, Sushil Pandit.
No, but if he's being called Sushil Pandit, I should be referred to as Karunanidhi.
Okay, Karunanidhi. Yes. I'm sorry. Karunanidhi, please allow Mr. Sushil Pandit to make his point. Yes.
Please make your point.
Ms. Nandi, what you are arguing for is not permissible as far as I am concerned. As far as my right to live in a safe country, it is such calls that led to the genocide of an entire community from Kashmir. 500,000 of us have not been able to live in our homes. None of our murders, massacres, rapes, and abductions have been prosecuted. Those who are advocating.
On that, I am with you.
You cannot be partially with me and partially with those who are responsible for my genocide. You cannot run with the hare and hunt with the hound. You have to take a position. And this cannot be, I'm on one hand this and on one hand that. Please look at things in totality. This is the consequence of playing footsie with those who advocate insurgency, jihad, and stand by them for their violence, which they unleashed on us, on unarmed, hapless people just because they professed a different faith. This cannot pass. It is the largest, biggest genocide in independent India in the last 75 years. What has been done with this? You being a lawyer, I'm sure you are conscious of this, you are aware of it. Did you move a petition? The same Supreme Court threw our petition out thrice, asking for justice for the victims of this genocide. Where were you? Where were lawyers like you who are today perturbed at application of a law for finding hair-splitting issues and interpreting law in this manner or that manner? Where were you when hundreds of thousands were evicted from their homes? Thousands. faced massacre, death, rape, and abduction, and their killers still roam free. Where is justice for that? Where is the justice? It is 35 years. Which Supreme Court judge stood up for this? Which judge resigned? Which judge wrote to the president writing letters like they did when their collegium was upturned and some certain judge was not appointed?
Okay.
They come to the streets addressing press conferences because a registrar did not put one case to this judge or to the other judge. Here a whole-scale travesty of justice took place, and there's crying shame that not one victim has been delivered justice. People are dying waiting for justice, and you're quibbling over whether this section is applicable or that. It is utter shame. It's crying shame.
Okay.
In this country,
okay, you made your point. Mr. Pandit, you made your point. Ms. Pandit, you made your point. Karuna Nandi, please respond.
I think he's making a very important point. If I may address this very briefly. Mr. Pandit, when the Kashmiri genocide was happening, and it was a genocide, I was a child. I do not go hunting for clients. If there are clients that come to me, then, and my pro bono quota is overflowing, whatever I can do, I represent them. I am with you. I am with the victims of the Kashmiri genocide. There is no two ways about that. Let me be clear. Number two, the fact that you are saying that I must agree with you on all issues, otherwise in your court I am evicted, is, I think, exactly the kind of thinking that we cannot no longer countenance. We must understand that there is a variety of thinking. It's the kind of thinking that leads to genocide. Today, there are people asking for a genocide in Kashmir on live television, online, and with complete impunity, they are asking for a second genocide in Kashmir. And that is not being prosecuted, sir. And that is something that you must look at.
No, absolutely not. Absolutely not. Nobody is asking for any genocide. Please, let's.
Madhav, you know, equating a genocide which was committed.
And might, sir, is what leads to
equating a genocide which was committed and is awaiting justice for the last 3 decades with a genocide which is feared, which is speculated.
I did not
which is speculated.
Okay. Let her complete a point, and I will give you a chance to rebut that as well, Mr. Pandit. Yes, Karuna Nandi.
So the point is, I think that we must understand that today, the speech that is being prosecuted is exactly the kind of speech that you will be prosecuted for tomorrow should the government change, right? Do you want to live in a society like that? Or do you want to live in a society that doesn't freeze, a government that has frozen the compensation rate for Kashmiri Pandits at 13,000 rupees? And that rate has not increased in the last 10 years. There has been no justice for Kashmiri Pandits.
Yeah, but Karuna, may I ask you a question? Karuna Nandi, may I ask you a question? May I ask you a simple question?
Is that not something that you want to ask for today instead of prosecuting people like Arundhati Roy?
Karuna Nandi, I have a simple question. Do you believe that this is a violation of the reasonable restrictions that are covered when it comes to freedom of speech?
The reasonable restrictions, that's a good question, Mother. The reasonable restrictions come into the design of the law, right? But if you look at this particular case and the law that is there in this case, the case actually no longer exists but for this UAPA provision that has suddenly been brought in 14 years later, and at a time that the court is on vacation, and most lawyers, and I mean, I'm in Delhi in the heat with all of you, but most lawyers are on vacation, right? So the timing of this is very suspect. The fact that the UAPA has been brought in is a real problem. But otherwise, the case actually no longer exists. But I want to speak to Mr. Pandit actually about what I think are very legitimate feelings on his part with regard to the lack of justice for Kashmiri Pandits. Because I think that is a very important issue, and I also think it's a separate issue. But I also think that this is an issue that has not been addressed by this government. And given that this government is aligned values-wise with the cause of the Kashmiri Pandits, let at the very least justice be provided there.
Okay. I think you're both at least on the same page on that. But Sushil Pandit, would you like to respond? We're almost out of time, but your response to Karuna Nandi.
Thank you, Madhav. No, first of all, I am very touched by Ms. Nandi's offer of taking up the case. I am reminded of Justice P.N. Bhagwati, who was the father of public interest litigation institutions in our courts. And he said, even a postcard can be a petition for the court. And then he went further. He says, forget a postcard. Courts should take a suo motu view whenever they come across any such violation that needs the intervention of courts. Lawyers, especially public-spirited lawyers, are known to have moved the courts for environment, for different violations, without anyone coming forward. If you are moved enough, and if the law has conscience, if the institutions are sensitive, you don't wait for someone to come to your door begging for justice. That's number one.
That's not
Number
true.
two, please, I did not interrupt you. I did not interrupt you.
Okay.
You did actually.
When you said don't interrupt, I kept quiet.
Okay.
Two.
Make your point, please.
Yes. Now, quibbling issues about whether this applies or not, whether it has been done 14 years later, and that this government should do something because it is aligned to our cause, is actually giving a free pass to all earlier governments.
That's fair.
Why? Why?
That
Why
is
should
fair
we be so lenient to them? I
agree.
demand prosecution of those who turned a blind eye, who refused to listen to us. We went to International Court, we went to UNHRC, we went to NHRC. In NHRC, Justice Venkatachalaya wrote a speaking order saying ours is a case akin to genocide. How many heads rolled? Who was made accountable? Where are the... Genocide is not a small crime. It's not a law and order situation. It's a heinous situation. We are signatory to the Convention on Genocide by United Nations in 1948. What have we done? Does our constitution have prevention and punishment of genocide for which our parliament is obligated? Has any lawyer raised this issue? We are missing in fulfilling our obligations as a state signatory to this convention.
All right. I have to come in now because we have to wrap up this discussion. We're completely out of time. I'd like to thank both of you, Sushil Pandit and Karunanandi, for coming in on this, because there are some very interesting perspectives that both of you have shared, and certainly, of course, that adds to this entire debate. Thank you both, Sushil Pandit and Karunanandi, for joining us, as well as our other panelists earlier, RP Singh, Lalit Ambardar, Suhail Seth, Kamru Zaman Chaudhary, Faisal Kashani and Monojit Mandal.